came to the fore. You have all these tribes crossing boundaries, and then suddenly you have these longitudes and latitudes restricting their movements. But before long, the African Union decided that we should leave those lines as they are, where they are as we find them, because to erase them would be even a bigger disaster. So you have these declarations as well with the Philippines. We declare that, we're assuming we're seceding from the U.S. and we're seceding to all the territories that the U.S. is giving to us. And that's also embodied in the Vienna Convention on the Law of Treaties, which states for us, a succession of states does not as such affect a boundary established by a treaty or obligations and rights established by a treaty and relating to the regime of a boundary. BCLT is the law that defines how we should interpret treaties between the United States. We have these declarations. As I said earlier, we did make this declaration in 1950 and 1960. It was rejected, but subsequent to our declarations we passed are the first baselines law. So we passed RE 3046. We used the straight baselines as first discussed in great detail with the ICJ in the Anglo-Norwegian Fisheries case. That's why they call the state baselines. States with highly irregular coasts may use the outermost points of their baselines and draw state baselines along these points. Basically, as you see, we have a highly irregular coast, and we cannot use the normal baselines approach, and that is what we used here, pursuant to this case with the US and Norway. The result is that the first delimitation of baselines, RE 3046 was amended by RE 5446. So I'll stop here. Just to say that if we look at the legal, the international constitutional law, we do have a strong claim as far as the status of the IETL, the international treaty, is concerned. But it's just the problem is that we seem to waffle all the time about the significance of all these declarations made by the U.S. towards the international treaty limits, and we don't seem to put much faith on these declarations. But in our petition, we actually said that. But we said that, but the big problem here is that we have the Constitution, and of course it's a principle. It's a basic principle that you cannot amend the Constitution by the passage of a statute of a law. And from a perspective, the new baselines law contravenes the Constitution, because now you have clearly all these problems that Professor Batongbacal is pointing at, the need to demarcate international sea lanes. If we maintain the international treaty limits, that will not be a problem. We will not have to open our internal waters to sea lanes. I mean, that's in the point. Of course, there has to be some way to look at our need to encourage international trade. But again, if you look at the differences in the legal regimes, if we stick to IETL, it will not be much of a problem. We are not obligated to under the UNCLOS, we will not be obligated to establish the sea lanes that's threatened biodiversity, that also threaten our security. Now, because of the baselines, the new baselines law, internal waters are now subject to innocent passage and overflight. And also, you have the principle established in our Constitution, again, about nuclear policy. With innocent passage and overflight, you can have nuclear vessels invoking innocent passage. Whereas if we refer to the Treaty of Paris regime, that is not possible. That will be a violation of national sovereignty. Of course, we don't have a navy, but so what? I mean, states won arguments. Sometimes they win arguments not by force but by the language of law. And they do. But the point is exactly this. The problem of biodiversity, you have under the new maintenance law, you just practically open the Philippines to all the sea lanes that also opens the Philippines to problems of pollution. For instance, to, you know, that 2 years ago, Greenpeace was saying there's a ship that carries toxic wastes from Europe to Japan, and it actually passed some parts of Philippine territorial waters. This is 2 years ago. And another point that I wish to raise is also the problem of the Kalayaan Island group. Because now under the baseline law, it has been reduced to a regime of islands. That also goes against the express provision of the Constitution. Now we look at the Philippine territory as an integrated whole, and that might weaken our claim over the Kalayaan Island group by reducing it to a regime of islands. We were saying that, perhaps an alternative way should have been to consider the Kalayaan Island group as an extension, as part of an extended continental shelf, which we do have the science to prove it. And I'm sure Professor Batongbacal is familiar with that. The UAE Law Center was part of these several institutions that tried to draft all the scientific, legal support for our claims to a continental shelf regime. But as I stand here, this is the problem we face now with our RA 9522. It really contravenes the Constitution, and the basic principle we know in law is that you cannot amend the Constitution by simply passing a statute. And on that note, I'd like to end the presentation. Thank you.
Thank you very much, Attorney Romano. I'm sure now your head is in a whirl because you've heard several narratives, but if you'll pay close attention, you'll notice that there are many similarities in the narratives of Professor Jay and Professor Romano. I'm sure you will have a very lively question period. One of the instructions of these two narratives would be that maps, they are very important. So for our last speaker, let's listen to, again, my former student, Henry Bansurto, Secretary General of the Commission on Maritime and Ocean Affairs. Henry is now a diplomat, and do I need to read the charter rules? No. But during the Q&A, please make sure that you do not attribute it to Henry, who might lose his job because he is a DFA. So this will be non-attribution. This will be a no-holds-barred discussion. But of course, you know that we are operating under the law of academic freedom. Agree?
Hello. Hi. First, I wanted to say good morning, good afternoon. First, my gratitude to my mentor, and I consider her my second and I learned a lot from Dr. Second is I'm grateful to be back. This is obviously homecoming for me. And in fact, I don't know how to get there here anymore because the names have changed. So it's one way now. But there's always the feeling of nostalgia to be back. I am a lawyer, but first and foremost, I am a political science student. I say student, not scientist, because I still consider myself up to this time a student trying to learn issues. And it is in that spirit that I come here. Don't mind the age. In fact, it's very refreshing to be here. And I decided to come here actually to engage because I believe this is part of public diplomacy, a policy that is not understood by people. It's not going to be effective. That. And this is also part of advocacy, actually, that for a long period of time, because of the very insular mind of people, and perhaps because for a very long period of time you were under US tutelage. Not that I'm saying it's totally bad, or of course, but I'm saying this in an objective way. This has caused us to be very inward looking, not knowing that there's a world out there, and with all this modernization and development, we are slowly growing out of our nutshell. Actually, I think that is something very good. I came here actually to talk about the archipelagic baselines, but since Jay introduced also the idea of archipelagic sea lanes, I'll try, if there is time, if I'm allowed, I will also talk on that. Although I would say that these two issues are very complicated, and I think half a day will serve its purpose. And how much I would suggest to Dr. Carlos to have another forum, perhaps a continuation, because we try to digest, in fact I would say literally 27 years of studying into half a day. I say 27 years because the baselines, because if you remember, the United Nations Convention on the Law of the Sea was ratified in 84. We signed it in 82 and 84, and for 27 years we got stuck. And this is my point. It's good to be cautious, but we should not be overcautious to the point of paralysis. It's good to analyze, but we cannot allow ourselves to be in that state of a continuing analysis without moving. We have policymakers are there to make decisions. Right? You have to make a decision, because a non-decision, then if you don't make decision, get out. Actually, because leave it to people who are capable of doing that decision. Every decision always has downsides, they have upsides. At the end of the day, policy making is about weighing all the considerations. And in fact, it is in that context that I'm trying to say that the baselines law is not just a legal question. It is both a policy question and a legal question. And I'd like to look at it first from the perspective of a political science student, because I see a lot of people who are very young looking. In fact, I would like to apologize to your chairman. I thought she was a student, and ma'am, sorry po. But that being the case, I think it is really a policy question and a legal question. And if you notice, I did it in a chronological way. Policy and then legal, because it's not the other way around. Legal is not the ultimate objective. Legal is supposed to be a means to reach an objective. And the objective is defined through those policy considerations. And it is from that perspective that I'd like to start this discussion. Time out na po. I came from a cold Canada, New York. Alright, so just like everybody, the two speakers, I'll try to present maps, because to tell you the truth, because of the highly technical nature of the issue, it's very difficult to understand the matter if you don't show maps. You will get lost. Even lawyers themselves get lost, I will tell you. But having said that, please, archipelagic baselines as a policy and legal question. Sorry, my technical. Alright. Thank you, Jay. First, I'd like to acknowledge Pala Jay and Attorney Bagagas, my colleagues. We're in the same profession. We disagree, but we agree to disagree. So that should be the case. We need not be disagreeable with each other. But at any rate, this is the presentation. And I titled it Up Close, Philippine Archipelagic Baselines, a Policy and a Legal Question. So it's a two-part series. And next slide, please. This is how we intend to go over it. Part one will be the policy imperatives. Earlier I said it's a policy question. It's a question of wisdom. Therefore, there are so many considerations that we have to take into account. And that's what I'm going to go through with you. And then from there, I will proceed to the legal issues. And many of those points were actually raised by Attorney Bagagas, and I'm grateful that he presented that perspective. Then we can look at the other side of the coin. So from there, I will discuss the United Nations Convention on the Law of the Sea, the Treaty of Paris question, and the question of internal water. All right, next slide, please.